Hello and welcome, everyone. My name is Ku Lee. I'm the Targeted Outreach Director for the California Department of Financial Protection, also known as DFPI. Thank you for joining the webinar today. Let's give everyone another, let's say, 2 minutes. 2 more minutes before to give everyone a chance to get logged in. I know it's right at noon, so thank you for your patience. We'll be back in 2 minutes. Okay. Hello and welcome, everyone. Again, my name is Cooley. I'm the Targeted Outreach Director for the California Department of Financial Protection Innovation, also known as the DFPI. Today's webinar, financial education webinar, is on finding out, learning more about your rights and getting help with debt collection. We have two really great guests. Let's go ahead and get started. First, a little bit of housekeeping. This webinar is being recorded and it will be published to our YouTube channel. Your cameras and microphones have been turned off for the duration of this webinar. But if you do have any questions, please feel free to submit it into the Zoom's Q&A feature. We have a dedicated time at the very end to do our live Q&A. The views and opinions expressed in this presentation are those of the presenters. They do not necessarily reflect the views or positions of the DFPI. This presentation is for educational and informational purposes only. This is not financial or legal advice, and the DFPI does not assume responsibility for the completeness of the information presented in this presentation. Again, as a reminder, please, if you do have a question or comment, please feel free to put it into the Zoom's Q&A feature. We will be answering those at the end. And we are recording this webinar. It will be published to our YouTube channel. And I will be sending out a copy of these slides to everyone who registered for the webinar. Okay. Just to talk about the DFPI. Who are we? What is our role? We are California's financial regulator. Our purpose is to maintain a fair, healthy, and trusted financial marketplace for all Californians. We do this through regulating and enforcing a variety of financial laws on financial services, products, and professionals in the state of California. And we also provide free presentations and workshops all throughout California to help protect consumers, to help inform them, and prevent them from falling prey to frauds and scams. For more information, we have a dedicated webpage for consumers where we publish consumer alerts, news articles, financial education. It's dfpi.ca.gov/consumers. So talking about the DFPI, who do we license? Who do we regulate and oversee? Here's a whole list. I'm not going to read through this big giant list. We have a lot of different financial professionals, industries that we license and regulate and oversee. I do want to highlight again, because this is a webinar to get help and more information about debt collection. We obviously license and regulate debt collectors. So if you are having an issue with a debt collector, maybe they're violating your rights, please feel free to contact us, submit a complaint. We want to review those complaints and help find a solution for you. One more plug before we jump into the actual content. The DFPI offers free online financial education. All you got to go, and it's open to anyone and everyone. You got to go to dfpi.ca.gov/learn. It's a learning platform that has a lot of different free course topics and modules on things like budgeting, investing, getting out of debt, building credits, buying a house. So please feel free to check out. Again, open to anyone and everyone. You just need an email to register to access that online financial education. Okay. With that, I do want to talk really quickly about what is debt collection. When a debt becomes overdue, the original creditor may try to collect on that debt, or they could also turn it over or sell the account to a debt collector. When this happens, they may report the unpaid debt to credit bureaus, and you may be contacted by that creditor or the debt collectors. Because of this, you need to know your rights, and so that you may be able to respond and act accordingly. With that, I do want to hand it over to Sean. Sean Clark. He is the DFPI's financial institution examiner from the DFPI's debt collection licensing program. Thank you, Sean, for being here. Please take it away.
Thank you, Coop. Good afternoon, everyone. Yeah, as you said, I'm a financial institutions examiner with the debt collectors program with the DFPI. You can go to the next slide. So today I'll be going over some of the laws surrounding debt collection and the framework that influences our regulation, including the Debt Collection Licensing Act, the Rosenthal Fair Debt Collection Practices Act, and the California Consumer Financial Protection Law. And then I'll dive into some more consumer-related hands-on examples and demonstrations about bad practices in debt collection, certain exemptions that exempt certain financial industries and professionals from not holding this license, and then some additional resources for consumers to reach out to. We can go to the next slide. So the Debt Collection Licensing Act, also known as the DCLA, it sets out to provide oversight and regulation of debt collectors operating in California, which means either headquartered in California or collecting debt from California debtors. So any form of debt collection occurring within California is what we seek to regulate. It aims to protect consumers from unfair, deceptive practices in the collection of consumer debts by requiring these collectors to obtain a license. The program is responsible for enforcing the DCLA, which includes supervising licensees, conducting investigations, and ensuring compliance with the law. Essentially, a key takeaway point, this gave us the right to license and regulate this industry. We can go to the next slide. So the Rosenthal Fair Debt Collection Practices Act, also known as Rosenthal, this is the California-specific law that regulates debt collection. Its federal counterpart would be the Fair Debt Collection Practices Act. So Rosenthal is California's specific law that regulates collection practices in order to protect consumers from abusive behavior by debt collectors. It provides a framework for seeking remedies against unlawful collection and allows consumers to pursue legal action if their rights are violated. And some key elements that define the regulation and that it seeks to eliminate are abusive practices. Collectors can't use or threaten to use violence, cannot falsely threaten debtors that failure to pay a debt will result in a criminal accusation, and they cannot use profanities, obscene language, or other abusive type language. It also makes a stipulation regarding the collection of time-barred debts. Now, a time-barred debt is once a debt has passed its statute of limitations. It varies depending on the debt type, but typically it's 4 years. And once the debt has passed said statute of limitations, collectors still are within their rights to collect on the debt, but they can no longer sue the debtor, and meaning they can no longer threaten to sue the debtor either. There's also regulations and guidelines regarding phone calls. Collectors cannot repeatedly call the person to annoy them, nor communicate at a frequency that could constitute consumer harm. We'll go to the next slide. Now, the California Consumer Financial Protection Law, CCFPL, expands the DFPI's oversight to better protect consumers and to keep up with emerging financial innovation. Essentially, it expanded the authority and resources to primarily take action against companies to protect consumers. Also, it encourages responsible innovation, by clarifying regulatory expectations. And it allows us to oversee financial activity previously unregulated by the DFPI, for example, debt collection. And additionally, increases public outreach and education to assist vulnerable populations. And we can go to the next slide. Now for bad practices in debt collection. So these are some of the big ones that I see when I'm looking over complaints or pouring through industry examples or documents. Number one would be harassment in any form. Debt collectors are prohibited from making repeated phone calls, threats of violence, or using any abusive or harassing language. Misrepresentation. Collectors can't misrepresent the amount owed. They can't falsely claim to be attorneys or working for the government in any way, or they can't threaten to take legal action in which they cannot take. So if they're within their rights to take legal action, they're allowed to explain that and use that as a threat. But if, for a time-barred debt example, if they don't have any legal claim to take action, they cannot use it as a threat. Unauthorized contact. Debt collectors are not allowed to contact consumers at inconvenient times or at their place of work without the debtor's express permission. And then a big one here at the end is failure to provide verification. If you are contacted by a debt collector, they're required to send you a validation document, which lays out who the debt is owed to, who the debtor is, the amount of the debt, and your ability and how you can dispute any portion of the debt. So if a consumer disputes a debt, whether it be they don't recognize it in their name, they've never heard of it, or they disagree with an amount expressed in the validation letter, if they dispute any of that, the collection agency must provide verification of the debt, and failing to provide that prior to attempting to further collect that debt is a violation of the consumer's rights. We can go to the next slide. So there's certain DCLA exemptions. If you are contacted by a debt collector and wish to determine through, I'll lay out some resources on the next slide that you can do so with. If you want to determine whether or not they're within their rights or licensed in California to collect a debt, it's important to know that certain depository institutions are exempt from holding this license, such as FDIC insured banks, credit unions, DFPI licensed finance lenders and brokers, and DFPI licensed mortgage lenders and servicers. There's some other business activities and debt collection activities that fall under that are exempt from holding a license for those specific activities, but those ones I just listed are the big ones. We can go to the next slide. So here are some consumer resources. Like I said earlier, if you're in a position where a debt collector has contacted you and you want to verify that they're licensed and within their rights to collect this debt, I would recommend visiting this link, the NMLS Consumer Access. You can type in their name, look up their information on whether they are licensed or not to determine that, or file a complaint directly through the DFPI. There's links there that will take you to the DFPI website and allow you to file a complaint against the debt collector there. If you have certain questions surrounding your rights or the debt collector's rights as far as the law goes, I would recommend going to the link here, Debt Collection Consumer page. It's on the DFPI's website, and it will have regulations, laws that lay out both consumer and debt collectors' rights. If you have a very nuanced question, we'll have a Q&A here at the end of the webinar to discuss any more nuanced specific questions. But I would recommend directing those as well to the dcla.inquiries@dfpi.ca.gov. We have a team in our program that is dedicated to checking that and ensuring both industry and consumers alike get clear, concise, and full responses to their dilemmas. And that is all I have, I believe. I'll throw it back to you, Ku.
Awesome. Thank you so much, Sean. Sean He's a financial institution examiner with the DFPI's debt collection program. A lot of great, fantastic information. Again, as a reminder, I do see some questions coming in. Please feel free to type in your questions into the Zoom's Q&A. We have a dedicated time at the very end to answer those questions. With that, I do want to talk about the DFPI's complaints process. It's one of the most common questions that we get when I do resource fairs or workshops. The question we get is, how do I submit a complaint, and kind of what can I expect? And with that, next couple of slides, I'm going to be talking about the whole process. First, the thing, if you're looking to submit a complaint, and it could be about a debt collector, it could be about any other financial professional or institutions or industries that we regulate. It could be a scam or a financial fraud that you have observed. You can always submit a complaint to a DFPI. The link is actually in our step 2 there, dfpi.ca.gov/submit-a-complaint. So the first step is you want to collect and organize your information. If you've ever submitted a complaint before, if you go onto the website to look at the process, it's a giant web form. And again, you can complete it online, or you could download an actual paper form, download and print a paper form to fill it out. But you do want to gather all the necessary information and details involved with your complaint. And that could include things like dates, times, names of people that are involved, as well as the businesses, any receipts, contracts, emails, letters, and any other supporting documentation. So could be kind of communications, messages that you've been sending back and forth. You need all that information to submit with your complaint so that we can review it all, kind of get a good picture and idea of what's happened and how the communication was going. That's your step 1. You want to, again, collect all that information. Step 2, again, go to our website, dfpi.ca.gov/submit-a-complaint. And from there, again, you can submit your complaint electronically, which is a giant web form, or you can download and print a form, which you can hand fill out, and then, of course, mail all that, the form plus any kind of supporting documentation to us. Step 3, again, you want to enter all the information online. If you're doing it online, you can upload all your documents. It makes it a lot easier for us. Plus, you kind of keep the originals. Again, make sure your statements are clearly detailed and explains what's happening, as well as talks about all the supporting documentation that you are uploading or attaching, and tells us what it is that we're looking at, right? Receipts, emails, that kind of a thing. Please don't include any personal confidential information, such as your social security number. We don't need that. And then after you have your form filled out, all the documentation submitted, uploaded, that's when you can submit your complaint form. And again, if it's electronically, you just hit submit. But you could also, again, mail us your form plus all supporting documentation to our address. That's our headquarters location, which is 651 Bannon Street, Suite 300 in Sacramento. Finally, once you've submitted your complaint, you could check the status. You will get once we receive your complaint, you will receive a confirmation number with a complaint number. That's kind of the most important thing you need. You can always return back to our website, use that complaint number, that reference number, to check on the status of your complaint. And you could also call us with that complaint number to get more information about the status of your complaint. And that's it. 5 steps to submit a complaint to DFPI. Again, if it's with a debt collector or it's with any other bank, credit union, investment advisor, mortgage lender, student loan servicer, we have a whole lot of industries that we license and regulate and oversee. When you submit that complaint to us, we're going to review it and try to get you some help. With that, I do want to hand it off to Elizabeth Gonzalez. She is a senior supervising attorney at Public Counsel. Elizabeth, thank you for joining us. Please take it away.
Hi, good afternoon, everyone. I always want to start with this identity theft or fraud information because I find that a lot of folks don't look at their credit reports very often, or if they do, they're looking at it from like Credit Karma or Experian Boost. So the first thing that I want to suggest is that you actually pull your credit reports from annualcreditreport.com. There's a QR code there if you want to go ahead and scan that. This is the official free credit report website that is worked with all three credit bureaus and the United States government. You can currently get a free credit report every week from all three bureaus, and it will not harm your credit to look at them. The reason that I suggest annualcreditreport.com is, and I saw a little bit in some of the questions, if you're getting them from like a Credit Karma or from Experian Boost, you're getting their version of what they want you to see. And so the annualcreditreport.com is going to be sort of the more general, this is going to give you the delinquency date, when it's going to fall off your credit report, things like that. So when you pull your credit reports from annualcreditreport.com, just make sure that you're looking at it to make sure that you're recognizing all the accounts. If you don't recognize them or you think there's something wrong, you can dispute them, and there's instructions on how to do that when you pull the credit reports. And if you are not regularly reviewing your account statements for credit cards or bank account statements, you definitely want to do that, because that's one of the first things that you'll notice before there's a bigger purchase. So if you're finding like small dollar payments, small penny payments that you don't recognize, go ahead and try to do an investigation. Reach out to the bank, reach out to the credit card company, say, I don't know what this is. They should be able to like pause any charges while they investigate if you would like. If you do notice charges that you did not authorize, you do want to dispute them as quickly as possible. There are some time limits as to how long you can take to dispute a charge, like on a credit card, in order to get some relief under federal laws. So you want to do it as soon as possible. So if you don't review your statements every month, go ahead and do that. Make sure that you're making that all the charges that appear are actually yours. If you have been the victim of identity theft or fraud, or you just kind of want to protect yourself, you have the option of adding a fraud alert or security freeze on your credit. One of them is sort of a 90-day kind of, they just check in, make sure that you're the person applying for credit if someone does apply for credit. There's a longer one that's 7 years, and basically once it's frozen, like you can't get credit. So if you're not in the market for a new car or a house or a credit card, and you just kind of want to protect yourself, you might want to do that. It's free. There is a way to remove it, but you do have to provide some information to the credit reporting bureaus. So just a couple tips to sort of preemptively help you with those identity theft or potential fraud charges. Next slide, please. So one of the things that I always want to talk to folks about is if you have current balances on your credit card or on your loans, and if you have been behind on your debts for a long time, you may actually never have to pay them back. The law limits how long a creditor has to sue you on unpaid debt. Generally speaking, California, we're looking at 4 years and 30 days from your last payment. And that's really important because I want you all to remember 4 years and 30 days from your last payment, and also know that if you make even like $1 of a payment, that 4 years and 30 days starts all over again. So if you have not been paying for 3 years, 4 years, you can't even remember, that's a good reason to pull your credit report. It will show you the date of your last payment, and you can just count 4 years and 30 days from that, see if they're even able to sue you on that. If you end up getting sued on a debt that has been more than 4 years and 30 days since your last payment, you might have some good defenses on that. So you definitely want to check that your credit report. If you have old debts and then you think, oh, I want to sort of consolidate, I want to take out a new loan and pay everything off and start all over again, you can do that. But if you're beyond the 4 years and 30 days, maybe you don't want to do that. What I always suggest is that you reach out to a free legal clinic. There are clinics and nonprofit organizations like Public Counsel up and down California. So reach out to a nonprofit organization. They can help you determine your rights, whether the debts are beyond the statute of limitations or not. Next slide. So a lot of times people, when I say that to them, they say, okay, but what about my credit? And I say a couple of things. Credit scores really only matter if you're looking to get more into debt. And so for the most part, when people say, but my credit score, and I say, are you looking to get more into debt? And they say no. Well, then don't worry about your credit score. Um, if you are thinking, oh, I might need a new car or I might need to rent an apartment, those are different stories, okay? But even then, what I always say to folks is it's not that you're not going to be able to get a car loan or a credit card, it's just going to be at not great rates. But if you've already defaulted on credit, that damage kind of has already been done. So even if you start paying or you pay off a lump sum, someone who's running your credit will still see what you previously defaulted on, how much you owe, things like that. Okay. Um, what I also say is 7 years after your 7 years and 30 days after your last payment, the entire debt just falls off your credit report. Okay, so that's another reason you want to pull your credit report. Look, if you get it from annualcreditreport.com, there'll be a little notation that says something like scheduled to be on record until. That means that after that date, it's going to fall off your credit report. The other thing that I explain to folks is you have a right to know if you have been either denied credit or been given credit at worse rates because of your credit. So if you believe that you were denied credit or given worse terms, you have a right to request what's called an adverse action notice explaining why you were denied. Now, these creditors should just give it to you, but especially for like smaller landlords, they might not know the law. So I've put up a QR code where you can get some information on what that adverse action notice has to entail. The big thing is that they have to tell you which credit report they used to make the decision. And so once you know that report was used, you can request a copy of it and make sure that it's correct. Okay. So if there's wrong information on that credit report they used, then you can dispute it. And then maybe that will help you get that apartment or get a better rate. And so, we don't want to make that assumption that, oh, I have bad credit, so I'm not going to get an apartment. You have a right to apply for the apartment. If they deny you and it's because of your credit, they've got to tell you that. Next slide. So I know Sean sort of went over some of these things, but I just want to get a little bit more into some details about the Fair Debt Collection Practices Act, which is the federal law. So the FDCPA is sort of the federal version of the Rosenthal Act that Sean mentioned. Unlike the Rosenthal Act, it really only applies to debt collectors or buyers. So it doesn't apply to those original creditors. So if Chase or Capital One is doing something that you feel is wrong in terms of debt collection, you might have a remedy under the state Rosenthal Act, but maybe not under the Fair Debt Collection Practices Act. California also has a Fair Debt Buying Practices Act. So when you have all these three protections together, you actually have some significant rights under all three laws. So these laws, as Sean mentioned, limit what debt collectors, debt buyers, and original creditors can say or do to collect debts from you. They give you the right to ask these creditors or debt buyers or debt collectors to stop contacting you. And they require these creditors and debt collectors to have certain pieces of information and give you information about the debt before they can take any action against you. So a little bit later on, I'm gonna give you a QR code for what we call a no contact letter. So if you are being harassed by creditors, you can send them this no contact letter that basically says, hey, leave me alone and also give me information about the debt. And until you give it to me, you need to not even try. Okay, so next slide. And here we go. So if you are getting phone calls and letters collecting on debts, and they're really stressing you out, and this happens all the time. I also run a bankruptcy clinic, and most of the time people come to us because they're fed up with the phone calls and the letters. So what we often suggest is that you send a no contact letter. So if you scan that QR code, you'll be able to find a sample no contact letter. It's a packet. It gives you a little bit of FAQs, like why am I sending this, a sample, and then one that you can fill in and send out to all of your creditors. Once you send this, a debt collector can send you information about the debt. So they can send what's called the validation. So they can send you, here's some statements, here's the account application, here's why we think you owe us this money. But aside from that, they have to stop calling and writing to ask you for payment. Now, they can sue you if they have the right to do that, but the constant barrage of phone calls and letter writing has to stop. Okay, so this is a really, really good tool to use if you're just feeling overwhelmed by those debt collectors. Next slide. So here's what I think Sean was sort of bringing in, but I'm going to like really dig in on this, okay? If someone is contacting you to collect a debt, you have the right to, and you absolutely should ask for some information, okay? Because if you're able to get this information, you'll be able to make the decision, you know, are they doing this right? Do they have a DFPI debt collector's license? Do they not? Do they really have the right to be contacting you on this? And so you have the right to get some information to help you make that determination. You can ask for the name of the creditor, the amount that you owe, what you need to do to dispute the debt. Next slide. I will let you know that you should never give out your personal or financial information to a debt collector. A lot of times you'll get a phone call from a debt collector or a debt buyer, and they say, I'm trying to reach so and so. And then you say, this is she. And they say, can I get the last 4 of your social security? Can I get your date of birth? No. Okay. Um, you do not have to provide them information about yourself. Okay. And at the very least, you don't have to do it until you know that they are rightfully collecting on this debt. Okay. But even then, you don't have to. Okay. Um, if a debt collector or someone is trying to collect on a debt and they can't give you this basic information, hang up on them. It's probably going to be a scam of some sort. Okay. If the debt collector uses like really abusive language, if they're threatening you, it could also be a scam, or it could just be someone, a debt collector, who's more than happy to violate state and federal debt collection laws and hope that they can get away with it. Okay. These are the times that you want to keep a record of those phone calls, those threats, and you want to file a complaint with the DFPI. Okay, because the more complaints the DFPI is getting about this phone number, this company, you know, the more they'll have to do a better investigation. Next slide. Some really big red flags, okay? If a debt collector says, you need to, I'm calling you because you owe this debt and you're a deadbeat and you need to pay us $500 right now. Otherwise, we've got a sheriff down the street and we're going to send them to arrest you. Or we've got a process server that's going to come to your house and we're going to embarrass you in front of your neighbors. So you need to give us money right now. If they do any of these things, hang up, okay? Because A, you can't go to jail for not paying a debt. If they are saying we have a process server around the corner, okay, let the process server come. They're trying to scare you into paying. And a lot of times they do this when they know they're either very close to or that 4 years and 30 days has passed. Because remember, if you make even a penny of a payment, that clock starts all over again. And you're giving them a right to sue you when they maybe don't already have one. Okay, next slide. Okay, so a lot of times folks are worried about getting a lawsuit. And so a couple of things that I want to highlight here is you want to make sure that you actually received the proper lawsuit in the proper way. Okay. If you or someone who lives in your home were not handed the lawsuit, you may not have to do anything. We are seeing a lot of reports of people being served by QR code or by email. Those are not valid methods of service. Okay. So unless you or someone in your household was handed that lawsuit, you may not have to do anything. If all you have is a letter, so there are attorneys who basically just scrape public records to see who's been sued on debt collection cases. And they will send out letters saying, hey, based on our review of records, it looks like there's been a lawsuit filed against you. And then in like really tiny writing, it says, this might not be actually your lawsuit. Because, you know, if it's a Joe Smith, they're just sending these letters to all the Joe Smiths. So be careful. If that's all you have, you don't have the actual lawsuit, you might not want to do anything. Go to the courthouse, see if you can pull up that case, see if it really is you. Because if it's not you, but someone that has your same name and you file a response, you're basically admitting that you are the correct person to have been sued when maybe you weren't. And that's really hard to get out of I've done it. It takes a lot of time. Um, so just be aware, just because you get a letter saying, hey, we're going to sue you, or hey, it looks like someone filed a lawsuit against you, that doesn't mean you actually have been sued. And just again, if you have questions about this, you can go to the courthouse, look up your name, look up the case number if they give you one, reach out to a nonprofit legal services organization for assistance. Next slide. So there you have several options. If you do actually have a lawsuit against you and you were actually served with the lawsuit. So you can agree to pay something. But what I will always say is don't agree to pay anything that you cannot afford. Okay. Um, if you end up paying less than you owe, for example, they're suing for $5,000 and they're saying, hey, we'll agree to accept $1,000. That $4,000 that you don't pay would result in taxable income to you. Okay, so we'll talk a little bit more about that later when we get into debt consolidation and settlement, but that could affect your means tested benefits like your Social Security disability, your CalFresh, your Medi-Cal. Okay, so you want to be careful about that. You can also file a response. If you file a response, it might give you some more time to decide, what is it that I really want to do? Okay, do I care if this goes to judgment? Do I want to file a bankruptcy? Do I want to fight? Okay. And if you file a response, you can address some defenses. So for example, we talked about that statute of limitations. If you believe that they have sued you beyond that time, you can say, hey, you sued me after you were allowed to, and so this case should go away. I will just caution you all that a lot of times I have never met somebody who like willingly really does not want to pay their debts. Every single person that I've talked to in my 16 years of doing this has been, I want to pay my debts. I just can't. Something happened. I lost my job. There was a global pandemic, whatever. Okay. So, but that is not a defense, right? You can't file a response to a lawsuit saying, I agree that I owe you, but I can't afford to pay. Because what you have done is you've just basically admitted to everything in the lawsuit, and there's going to be a judgment entered in against you. Okay. If you're not sure why you're being sued or who's suing you, a response can also help. Okay. A lot of times, these debt buyers, you don't even recognize their names because you never borrowed any money from them. You never had a credit card with them. You don't even know if they have the right to sue you. Okay. So you have the right to file a response to make them show that they actually do have the right to sue you and that the amounts they're suing you for is actually what you owe. So filing a response gives you a little bit more time to figure out your options, get some more information about the debt. You can also just do nothing. We're going to talk a little bit later about if you are what's called collection proof, meaning there's nothing that a debt collector or a debt buyer or a creditor can take, even if they have a judgment against you. Then you might not even have to worry about filing a response because they can't get anything from you by force anyway. Okay. And so if you're sort of like, oh, yeah, I'm not worried about it, then maybe you don't want to go to court and file a response and deal with all that. It's your decision. Next slide. So let's talk about sort of this collection proof aspect of it. Okay. You may have heard folks talk about being judgment proof. No one is judgment proof, right? Everyone can have a judgment entered in against them. It's just a matter of whether the creditor can do anything to force you to pay that judgment. Okay. So there are laws protecting your paycheck. There are laws protecting your bank accounts, your benefits, your car, your home. Okay. Just for ease of reference, I'm just going to throw out a couple of numbers. And I hope that these make sense because I know it can be a little bit jarring because math is hard. So if your take home pay, and by take home pay, I mean your gross minus required tax and federal and state deductions. Okay. So if you take your gross, let's say your gross is $800 and you get $75 taken out from all of those required deductions, you're left with $725, right? We're not excluding things like health insurance that you pay, dental insurance, things like that. Okay. Those stay in. If when you take your gross minus your required deductions, if your take-home pay is $792 or less per week, your wages cannot be garnished for just a regular credit card account or consumer credit. Okay. So this amount is based on the minimum wage. Okay, so it's always per week going to be 48 times the minimum wage where you work. Okay, so for those of you who work in San Francisco or Los Angeles or West Hollywood, higher minimum wage, so the protection is more than $7.92. At a minimum, $7.92 per week. Okay, this is an automatic protection, meaning you don't have to do anything. Your employer by law is not allowed to garnish if your take-home pay is less than that. We're going to put aside any questions about like taxes or student loans, things like that. What I'm talking about is if there is a judgment against you for just a regular consumer debt. Okay. If your wages are automatically protected, if your take-home pay, gross minus those required deductions, is never more than $792 a week, do not file a claim of exemption. A claim of exemption is for when you have more than is automatically protected. So let's say your take-home pay is $1,000 per week. You have about $208, math is hard, that could theoretically be garnished at 40%. So $208 times 40%, that's what they could take. If you're automatically protected and you file a claim of exemption, you're going to end up probably going in front of a judge who may not be aware of these automatic protections. And so sometimes judges think they're being helpful and they say, you know, instead of taking money every week, let's agree to like $50 a month, one time. And most folks are like, oh, okay. But if you had that automatic protection, you wouldn't even have to give that $50. Okay. Like I said, if you're not sure, if you have questions about whether your income is protected, reach out to a nonprofit law firm for assistance. They can do that math for you. They can figure out, looking at your pay stub, whether you're protected or not. Okay. Next slide. Government benefits are also protected. So if you get your benefits on an EBT card, that card cannot be taken from you to collect a judgment. Okay. If you take that benefit and deposit it into your bank account, you still have some other protections. Okay. If you're taking money, let's say from unemployment, and depositing it into your bank account, at a minimum, the bank is going to protect $2,244 in your bank account. And that amount increases every July 1st. And by bank account, I mean any accounts that you have in one bank, if they total $2,204 or less, the bank is not going to take any money to collect a consumer debt judgment. Okay, so that's an automatic protection. If you have benefits direct deposited into your bank account, like your Social Security, the bank is going to protect 2 months of those deposits, which could be more than the $2,244. But that's only if that's the only money in your bank account. So if you have your Social Security and then you like throw in $25 from a Zelle payment, the bank gets confused and they don't know what Social Security and what Zelle. They will at least protect the 2,244. But if your benefits each month total more than 2,244, let me rephrase. If 2 months of your benefit deposits are more than 2,244, you might just want to keep your benefits in that account and nothing else, because then you'll get more of a protection. Okay, so let's say your monthly benefits are 2,000. Bank's going to protect 4,000 of the benefits if that's the only thing in the account. If it's intermingled, there's other stuff in there, 2,244. Okay. I know I'm giving you a lot of information, giving you a lot of numbers. Just sort of at least keep the 2,244 bank account or less. You're good. You don't have to worry about a levy on that. Okay. And for your take-home pay, $7.92 a week. Okay. If you get paid every 2 weeks, twice a month, it's a little bit higher because it's based on the number of hours. Okay. I'm sure I've raised so many questions because I threw out numbers. We'll hopefully get to those, but hopefully this makes sense to you all. Next slide. Okay. A lot of times people are worried about their house or their car. In terms of a house, if you have equity in your property, meaning there is some value over what you owe on it, a judgment creditor cannot force the sale of your home based on a consumer debt, like for a credit card or a loan. Okay. They can put a lien on the property, a judgment lien, but they cannot force the sale. So the only way they get paid is if you sell or refinance the house. Okay. So hopefully that makes you feel a little bit less worried about your home. You can protect your car and other assets. Currently, there's a protection for equity in a car of over $8,000. So if you have a car that's worth less than that, or that the equity is not that high, they're not going to go after the car. And so if your wages, if your bank account, if all of this falls under these automatic protections, the only way a creditor is going to get money from you to pay one of these judgments is if you give it to them voluntarily. And so what I say is, remember, the state and federal governments have already said you need this money, so they're going to protect it automatically because this is how much you need to live. So if that's the case, why would you just hand over money if they wouldn't be able to get it from you by force? Okay, so think about that. Next slide. So if you do not have the money to pay, especially if you have what you have is protected, you don't have to pay. What's most important is that you take care of yourself. You pay your rent, you buy your food, you put gas in your car. If you don't have anything left over to pay those debts, especially if you have those protections, you don't have to pay them. Okay. But there are folks who, again, I've never met somebody who's like happy, yay, I don't have to pay my debt. It's usually like, oh my gosh, I feel so bad. So some folks ask me about debt settlement. And so what I just want to make sure you are all aware of is that for debt settlement, the first thing they ask you to do is stop paying your debts. Okay, so if you're worried about your credit's going to take a hit whether you do settlement or whether you don't. Okay, there's no guarantee that they're going to help you. So you will be paying upwards of $500 every month in the hopes that this debt settlement company is going to come to an agreement with one of or more of your creditors. Unfortunately, they do this in such a way that if you're paying like $500 a month, about 400 and some odd of that is just going to their own fees. So the money that's left over for you to actually settle a debt is like minuscule. So you'll find yourself making these payments month after month after month after month, and you're not getting any relief. So think about it. You're paying 500, of which 400 or something is going directly to this company fees. You probably need that money more than these debt settlement companies do. So think about whether that makes sense for you to pay. Even if you go to a debt settlement company and even if they say, oh, well, we're going to give you a lawyer if you get sued, the fact is you can still be sued. And you want to, if the reason that you're trying to go after debt settlement is because of your credit or because you don't want there to be a lawsuit, that's not necessarily going to help. And then, like I mentioned earlier, any amount that you don't pay, meaning is forgiven or canceled, is considered taxable income to you and will be reported on your next year's tax return. So if that, that might jump you out of your ability to get on Medi-Cal or have the earned income tax credit. So you want to be really careful about that. Next slide. Even though I've said all of these things, a lot of folks will still say, yes, but I want to do this. And that's, your choice. You get to make the determination, as long as you have the information. Please, 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 please don't sign anything you don't understand. Don't sign anything without reading it. Most of the time, these debt settlement companies, they're on the phone with you and they send you an email and it's like hundreds of pages of documents and they're on the phone saying, just go ahead and just click through, just sign, click, 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 because they don't want you to read what's in that. Okay. So if that's what's happening, stop, don't sign, make sure you have a chance to read everything and that you understand it. And if you have questions, that you're able to ask them and get answers. If they don't want to answer your questions, if they're pressuring you into signing, if they're sending you documents in a language that is not your preferred language, be careful, okay? If you don't know how much of that $500 a month payment is going to their fees versus towards actual settlement, be careful, okay? You make the decision, but at least you have a little bit more that you can do here. So I'm going to go to next slide because I feel like I'm going to be asked to stop talking soon. Oh, I'm done. Excellent.
Thank you so much, Elizabeth. I do want you to stay on real quick just to talk about Public Counsel. It's a great organization. I know I've referred a couple people and my team has to your organization. Please talk about Public Counsel for just a minute.
Sure. So Public Counsel is a nonprofit law firm. We are based here in Los Angeles. We serve folks across Los Angeles County, Kern County, and some San Bernardino County. We have a number of different projects. I work in our consumer rights and economic justice project. So I handle debt collection work, I handle student loans, I handle mortgage fraud, and we also have a bankruptcy clinic, and we don't charge for our services. And especially our bankruptcy clinic, anyone can come in from across the state because we can give that bankruptcy advice. This information is on our website. So if you scan that QR code for the no contact letter, you'll get to our website, and you can read a little bit more about us. But we are a nonprofit. We don't charge for our services. We do have some income limits, but they're pretty high. And there are other organizations like Public Counsel across the state. And so what I just really want to impart upon you is don't, when you're dealing with debt, things like this, don't pay somebody to help you, because more likely than not, you qualify for some free services.
Awesome. Thank you so much, Elizabeth. Again, that's Elizabeth Gonzalez. She's a senior supervising attorney at Public Counsel. A lot of great and fantastic information. And we have a lot of questions, so I'm going to hit the Q&A real quick. But before I do want to talk about debt collection scams, and I want you to be aware of them and try to protect yourself. I want you to recognize these red flags. So as we've talked about before, if a debt collector is threatening or harassing you, if they're trying to get some unusual payment method through like gift cards or crypto, if they're refusing to provide you information or demanding immediate action, then that immediate action, again, those debt collectors try to get you in that tunnel vision, trying to get you create that sense of urgency. And when that happens, you're going to miss out on some red flags. And again, if they give you any kind of inaccurate information or information that's not correct, you want to take your time, slow down, take your time, and you have your rights. Please use those rights. Otherwise, it could be a debt collection scam. So if someone is contacting you, claiming that that you owe a debt and they're trying to force you to pay, get their information, submit a report to us and to the DFPI, and you can also submit a report to the CFPB, the Consumer Financial Protection Bureau, who also oversees some debt collectors. So we would love to review, and also if it's a scam, we want to shut those down. With that, let's hit the Q&A. I know there's a lot of great questions. I'm going to just start from the top. I did see some questions that are kind of very nuanced, and some of them that have some personal information. So I'm going to skip those and hold those, and we'll answer those offline. First question, did I hear correctly that if a debt collector is not located in California, they can't try to collect that debt from me? And this might be a good question for Sean.
Yes, so that is, if I miscommunicated that, apologies. That's not correct. So if there any debt collector out of the state is attempting to collect a debt from a California debtor, they're within their rights to do so as long as they hold a debt collection license.
Great. Thank you, Sean. Next question. If a debt collector is harassing me, what should be my first step?
I mean, I would suggest, and I know there seems to be some disagreement about the no contact letters. So like I said, if you just are being very much hounded and you're stressed out about that, you can send a no contact letter, which includes the request for information. So that's kind of, killing two birds with one stone. But I think it's really up to you. You can get some more information. You can send a no contact letter. Try to see if they actually have the right to collect against you.
Awesome. Thank you, Elizabeth.
I would also add that you should file a complaint with the DFPI.
Yes, definitely. That's against the law if they're harassing you, especially if they're using some kind of threats of violence or other things. Submit a complaint to us. We want to know, and we want to try to stop that. Okay, another question here. How soon will this be posted to YouTube? Will it also be sent to us via email? Answer is yes. We are recording this webinar. We'll publish it to YouTube probably today. It just depends on how fast Zoom can process it and then how fast we can upload it to YouTube. It'll definitely be today, probably later on tonight. And then I will be following up to everyone who registered for this webinar with an email. In that email, I have a link to the YouTube recording, also a copy of these slides. So you're going to have it. Please share it. Thank you. Great question here. Longer question here. I'll just go ahead and read it real quick. I noticed that the initial date of delinquency and the date of deletion vary from bureau to bureau. Should they all be on the same page? This is more like a credit bureau question. If a bureau is reporting the incorrect removal or initial date of delinquency, can a consumer leverage that date as an error to potentially have the debt removed? So it's kind of a sorry, long, maybe nuanced question.
So what I would say is get your credit reports from annualcreditreport.com. I think that's going to give you the best, more accurate view. There was a question later on about like, is it different if it comes from Credit Karma or Experian Boost? Yes, the answer is yes, because Credit Karma is owned by TransUnion, so you're going to get a TransUnion credit report. Whereas if you just go straight to annualcreditreport.com, you get all three. Take a look at them. If you notice a problem, you can certainly dispute it based on the information you have. But I think after that, it's really it's a little bit too nuanced to give you a final answer.
Awesome. Okay. I know we're kind of short on time. I'm going to fly through these as much as I can. I was not a co-borrower on my dad's auto loan. He passed away due to illness. Am I liable for the loan he turned in the vehicle before his passing?
I feel like this is a legal question, but what I can say is generally speaking, the estate of the person who passes away is liable. So if there's no estate, then there won't be any payment.
Good. You know what? That's a very good. Now that I'm thinking about our estate planning webinar, yeah, that makes a lot of sense. Great question though, and yes, as a reminder, this is not legal advice. This is just simply informational and educational. So thank you very much. A debt collector served me at work. Can they do that?
So I believe they can. Unfortunately, the way the law is written, there is an argument that says that place of employment is a place of business. If you ask me, I have a different answer, but I think, yeah, unless Sean has something else he would like to say.
No, I agree. I probably need some more specifics on the exact instance, but there's nothing that says they can't serve you there if they've attempted to serve you at home prior and couldn't contact you or locate you.
Okay, thank you. Yeah, good question. And thank you, Elizabeth and Sean, for that. Are the credit reports banks provide more accurate than Credit Karma or Experian? I'm sorry, I'm not sure what they're asking.
I wonder if it's the credit score. And what I will say is that there are like 15 to 20 different credit scoring models. So if if your Chase Bank is saying you have a credit score of 750, but your American Express is saying you have a score of 700, it's because there's different scoring models. People don't really know that. So maybe that's what they were asking.
Okay. This next question is kind of long and it's a little bit nuanced. So I'm going to take that one offline and go to the next one. Next question is, I'm trying to buy a house, but I have a very old debt about 8+ years ago. I never paid after it went to a debt collector. Will this affect me negatively?
I'm going to say that's going to depend on the bank. But banks can actually pull your entire credit history for a mortgage. So it's really going to depend on the bank what they're looking for. So it's just going to depend on the bank.
Yeah, and check your credit report. Again, just like Elizabeth was saying, go check your credit report from all the 3 credit bureaus. If it's on there on your credit report, then it could be an issue. But 8+ years ago, it may not. So check your credit report. Next question, it feels more like an opinion less than a question. So I'm gonna take that question offline. Aren't adverse action notices supposed to be issued automatically after denial? Is it the consumer's responsibility to request this notice?
You are correct that they are supposed to be issued, but unfortunately, there are some places where they don't give them to you.
Okay, a couple more questions. Again, I'm not going to be able to get to some of the longer questions. This is great, by the way. We had a pretty good attendance and a lot of really great questions. This is a short one. Might be able to answer it quick. If I declare bankruptcy, will it clear out my debt from debt collectors?
You're going to hate this answer. It depends.
Yes.
So generally speaking, if you file a bankruptcy, your general debts will be discharged. There are some that are not automatically discharged, but I just want to clarify, it doesn't clear out from your credit report. The debts are still there. There's just a notation that says discharge in bankruptcy, so you don't get a fresh, clean credit report after bankruptcy.
Okay, we have two more questions before we got to wrap. So I'm thinking about settling with debt collector. We actually had a slide on this. What contract paperwork do I need to make sure that I am protected?
Just read it if you don't understand it and they won't answer a question, maybe go with a different company or not at all.
Great. And then let's wrap up with this last one here. What about, two more real quick. What about the nonprofit credit counseling agencies? I don't really know. So I know credit.org, they're great, and I love them. They have free credit counseling, and you can always just set an appointment with them. Any suggestions, Elizabeth? Any thoughts on this?
I mean, I think it's sort of the same. Like, it's ultimately your decision. If you don't have the money to pay and you are collection proof, do you need that money for your rent instead? So that's sort of where I would go with. Nonprofit is better than for profit for sure, but it's really, can you afford to pay anything?
Great, thank you. And we'll just wrap with this last question. Elizabeth, how can I get an appointment with you or your organization?
So not with me personally, but if you go to publiccounsel.org, I think our debt collection intake is currently closed. Our bankruptcy is open. So if you have questions about bankruptcy or related to debt collection and bankruptcy, you can make an appointment there. But public counsel, the way it's spelled on the slide, .org, you can reach out to us. And you can also go, I think, lawhelp.ca.gov, maybe. You can also find others that are maybe not necessarily in Los Angeles.
Yes, there's definitely a couple of different nonprofit law organizations, legal organizations out there that provide assistance. I think there's one in the East Bay. They're really good. I like them too. And yes, you can just Google to search them out. They're there. Okay. With that, I do want to just do a quick wrap up. As a reminder, please subscribe to the DFPI's newsletter. You may have heard about this webinar because of that. You could just subscribe at dfpi.ca.gov. And then, of course, our YouTube channel where we will publish this webinar as well as all of our other financial education webinars. It's youtube.com/CA-DFPI. Finally, just a reminder, next month, our next financial education webinar will be on October 1st, right at noon, and that's our home buying workshop. So please register for that if you get a chance. Thank you for everyone for attending. Thank you for our guests for being here, Sean as well as Elizabeth. A lot of fantastic and great information. Thank you for attending today. Please take care of yourself and each other. Have a great day. Bye.